Senator from Nebraska, Senator Sass.
Thank you, Chairman. Judge, welcome back. By my quick eyeballing count of this, you are 51% done as of this moment, which feels more like curse than blessing, but I meant it as a good thing.
Thank you.
I think
So this could go until midnight. That's not a joke. That's because if we're halfway done, we're 7 hours in.
all for spending time with me in my office, and thank you for answering the questions of the committee today and tomorrow. What you've said in public matches what you've said in private, and that's obviously a testament to your character. That also can be helpful to rebuilding public trust. So thank you for the ways you've engaged thus far. Judge, you are likely to go on to serve a lifetime appointment on the Supreme Court, which means that this is very likely the last job interview you ever have.
And the most public, Senator.
Yeah, these processes are a lot like a proctology exam. That means that it's an opportunity for you to explain to the American people how you view a Supreme Court justice's job and the limits and bounds on that job. So I want to go back to a topic that you and I have discussed a few times, which is how you approach cases. You've told this committee and you've told me in private that you don't have a judicial philosophy yet, but that you think of yourself as having more of a judicial methodology. I'd like to understand that a little bit more. And I think it would be helpful for the American people to understand that argument and that distinction a bit more as well. Earlier today, you said that you, quote, do not believe there is a living constitution. And you also said that you're constrained to interpret the text, and that's, I think you said sometimes that's enough to resolve the issue. So I think I've heard you pay partial tribute to the judicial philosophy of originalism, but you've not adopted it or embraced it as a philosophy or label that applies to you. So maybe one of the places we could tease that out a little bit more is trying to dig into whose jurisprudence you most admire. We've heard many nominees before, like Senator Grassley, former chairman of this committee. I'm not an attorney, so the farming and ranching people where I come from know that John Kennedy is super smart Rhodes lawyer who kind of pretends to be a, aw shucks kind of guy as he picks your pocket.
Oh, God.
Grassley and
Do I get equal time, Mr. Chairman?
he always gets unequal time. He always gets bonus time. But I think it might be helpful for us to understand who you most identify with, and past nominees before this committee have talked about the mold of particular justices they thought they followed in. And so if you had to tell the American people who you're closest to, who is that justice, or who are those justices?
Well, thank you for the question, Senator. And I must admit that I don't really have a justice that I've molded myself after, or that I would. What I have is a record. I have 570 plus cases in which I have employed the methodology that I described, and that shows people.
This is smart. If you name anybody, then they'll find the worst or most controversial decisions of whoever she names and ask her to say whether she agrees with those decisions. It's a minefield. This is a smart approach.
I've thoroughly all of the arguments that are made in the case to me as a judge, because I want, in my lengthy opinions, for people to understand the inputs. This, I say, is what I'm considering, because I lay out in very, detailed way everything that people have argued in all of the cases. And then when I'm doing my interpretation, I am focused on the text of any statute or constitutional provision. I am looking as appropriate to the intentions of the people who wrote the words, because I view statutory interpretation, constitutional interpretation, those exercises consistent with my limited authority. I am conscious of not interpreting those texts consistent with what I believe the policy should be, or what I think the outcome should be. I am trying in every case that involves that kind of interpretation to assess what it is that the parties who wrote the text intended. And as a result, because my methodology involves these various pieces and because of the way in which I do things, I'm reluctant to establish or to adopt a particular label, because the idea of how you interpret is just one part of the entirety of a judge's responsibility. As I mentioned, I'm looking at the facts in a case, and my experience as a trial judge helps me to assess the facts from all of the different perspectives of the parties, because I'm able to do that, I think, having heard from parties in all sorts of cases directly as they present their arguments. That's a part of the judging responsibility that isn't really captured by something like originalism or living Constitution. And I believe that the Constitution is fixed in its meaning. I believe that it's appropriate to look at the original intent, original public meaning of the words when one is trying to assess, because again, that's a limitation on my authority to import my own policy views. But there are times when the meaning, unreasonable searches and seizures, due process, looking at those words are not enough to tell you what they actually mean. You look at them in the context of history, you look at the structure of the Constitution, you look at the circumstances that you're dealing with in comparison to what those words meant at the time that they were adopted, and you look at precedents that are related to this topic. All of those tools judges use, and I have used, is if you look at my cases.
But when you say that you look at the intent of the
Yes.
authors of a statute, sometimes courts have to say the people who wrote this statute, whether they meant to or not, have done something that we, the judiciary, decides, speaking in the voice of you, is unconstitutional. And deciding that something is unconstitutional requires an interpretive framework for how you get there, right? And so you and I talked in my office about the differences between Justices Kagan, Breyer, and Sotomayor's judicial philosophies, and you told me that you needed time to study that issue further. So assuming that you've had a chance to think about that a bit more, I guess I'd ask you again, what are the differences among the three of their judicial philosophies?
With respect, Senator, I have not actually had time with all of my meetings with senators and the work that I've done to appear before you today. I would say that there are differences, as you see from the various opinions that they have issued. I'm not sure.
Yeah, I also don't know that it makes you more qualified to be on the court to be able to present a book report about the different philosophies of three justices on the court.
Are looking at different provisions. They are using the various tools that judges use and that I have used in my cases. The idea of striking down a statute as unconstitutional is daunting and should be daunting, I think, for any judge or justice, and would have to be looked at very carefully because of the limited nature of the judicial role and the fact that the policies have been adopted by the branch of government that has that authority under the Constitution.
So I guess I'm surprised after 9 years on the bench that, I mean, you're super smart. Nobody disputes that. And having worked for Justice Breyer and knowing of some of the fights, some of the philosophical arguments he and Justice Kagan had, it just seems surprising that you wouldn't be able to at least not speculate, but reflect a little bit on the nature of those disagreements. Because to say it depends on the particular case, that's fine, but they have different philosophical and hermeneutic approaches to the text. So maybe another way to get at it. I think Justice Breyer, again, for whom you clerked, and Justice Scalia used to travel together and have lively debate circuit conversations. Can you tell the American people a little bit about what Breyer-Scalia roadshow looked like? What were they arguing about?
Well, my understanding is they were arguing, or at least presenting, two different viewpoints as to how the Constitution should be interpreted. And I would say, just as an aside before talking about their positions, that while I have been on the bench for 9+ years, the issue of constitutional interpretation in that sense doesn't come up very often. It comes up to the Supreme Court for sure, but it doesn't come up very often in the lower courts. What Justice Scalia and Justice Breyer, I believe, were debating was Justice Scalia's notion of originalism, meaning that the words of the Constitution should be interpreted as they were written by the founders in the founding era, and that they should not be considered to essentially to establish principles that modern justices could now apply based on their own view of the needs of society. And that Justice Breyer's position was more toward that latter view, that the idea of the Constitution needing to be interpreted in a way that is consistent with modern sensibilities about the principles that the document reflects. And I would just say that it appears now that the Supreme Court has taken Justice Scalia's view that the prevailing interpretive frame for interpreting the Constitution is now very clearly looking back through history. So we see that even in the Heller case, where the justices, even the justices in dissent, were all analyzing the issues in the Second Amendment through a historical lens, what was meant at the time of the founding. So that is now the way in which constitutional interpretation is done.
But do you identify with that position?
I identify with the position insofar as that's how the text is interpreted of the Constitution. That I am a strong believer, as I said, in precedent, in stare decisis, in predictability, in the rule of law, and the way that the law now interprets the Constitution is through this historical frame.
I'm grateful for your last couple of minutes because I think that it's in the American civic interest for us to understand these different schools. Again, non-lawyer here, but my simple way of summarizing some of what I think I heard you just say is that Scalia argues hard that the Constitution has a fixed meaning and justices aren't really free to depart from it without a constitutional amendment passed by the political branches so that the voters get to hire and fire the people or have a role at the state level in the ratification of a constitutional amendment. And Breyer's position seems to me, and I won't get it precise enough in technical legal terms, jurisprudential terms probably to satisfy him, but that the Constitution is speaking to more abstract principles, and therefore there's a lot more play in the joints of what a justice's job is. And I think the way you summarized their debate was pretty fair. And I also think it's fair for us to want to understand what your position is about it, because you're obviously, as I've said, incredibly smart and incredibly likable and winsome and on the stage for a lot of Americans to look up to. I'm at the rah-rah, hear side of that debate at the level of what is a Supreme Court justice's job. I think that's why a lot of us are still trying to tease out the philosophical distinction, which I think is more than just a methodology, but want to thank you for that answer. You've also brought up the Fourth Amendment a number of times in our conversation, and I would like to talk a little bit more about the Constitution and whether its meaning changes. And so I'd like to go back to the Fourth Amendment topic you brought up in my office. You said, I think, that and correct me if I'm missummarizing your position, you said that originalism wouldn't have much to say about the Fourth Amendment because the Founding Fathers never conceived of a tool, a piece of telecommunications equipment like this. And so I think during our conversation, you said that the original meaning of the Fourth Amendment won't tell you much about what to do with a new technology. My guess is that originalists, and Scalia in particular, would disagree. So what do you do if the text of the Fourth Amendment...
This is by far the most sensible discussion that has been had with a Republican on the panel so far.
Just to clarify what I intended to say, and I may well have misspoken, there is an originalist take, I think, on the question of what happens with a cell phone. As the Supreme Court held in the Riley case, there was a way in which you assess principles of the Constitution, the text of the Constitution, and apply it to modern technology. And you have to, because there's no question that cell phones didn't exist at the time of the founding. So if the originalist principle is...
Now, that's a fact. That's not an opinion, okay? There were no cell phones when they did the Constitution.
...existed at the time of the founding, there would be no answer to what to do about a cell phone. And so what the Supreme Court has said and done is to determine that the principle of the Fourth Amendment with respect to searches is to determine whether there is a reasonable expectation of privacy. They also have looked at property interests with respect to whether or not there's an invasion of privacy, and then determined from history what that reasonable expectation of privacy related to back at the time of the founding, and analogized to current circumstances related to things like cell phones. It's a method of interpretation that allows you to, instead of the alternative, which would be, don't worry about the history, just look at the words in the Constitution and say, what do I think is reasonable or unreasonable with respect to police officers searching cell phones? That's not the way the Supreme Court handles it. They try to determine what was unreasonable historically, and then given those principles, historically it would be unreasonable for police officers to enter someone's home, to rifle through their papers and documents. They then analogize to current circumstances and the fact that a cell phone is like your personal file cabinet. And they say, okay, given what we understood the framers to have intended about the need for a warrant or the need for protection against unreasonable searches, we're going to apply that to modern circumstances. It's still an originalist way
Quite
of
sensible.
analyzing the current dispute.
So are there non-originalist ways to wrestle through that same question? And what would they be?
One could imagine that rather than referencing history at all, that the court would look at the Constitution. It says no unreasonable searches and seizures, and would just ask in light of modern sensibilities, in light of what we would think would be reasonable today, or what the court itself would think would be reasonable today, we'd apply that modern understanding to the cell phone situation. And the danger, I think Justice Scalia would say, is that that's a kind of framing that permits judges to make a determination based on their own views rather than hewing themselves, as Senator Lee said before, that Justice Barrett pointed out, hewing themselves to the text of the Constitution.
And does Breyer have a different view?
I haven't, I'm just trying to think. My understanding of the living constitutional principle is that it's closer to looking at the needs of modern society. But I'm not well versed in it, in part because the Supreme Court has now so clearly taken the historical perspective, the originalist perspective in its interpretations.
You brought up the cell phone example with me, but I know you have others. What are some other areas of life where the original meaning seems to be 2.5 centuries removed? What are places that the Constitution seems to not speak to?
Well, Senator, I'm reluctant to spell out different circumstances. What I will say is that when you look at the language in the Constitution, there are some provisions that are completely clear on their face without any question of what was intended. The age of the required age of senators, the required age of the minimum age of the president. These kinds of provisions, all you need is the text, and there you are. But there are provisions of the Constitution that are broader than that, and therefore some interpretive frame is necessary. And to the extent, I mean, every question the Supreme Court gets that involves new technology, for example, that relates to constitutional provisions will require some kind of analogy, I think. But, you know, I can't speak to anything more than that.
You have described Justice Breyer's constitutional approach as pragmatic. What does that mean?
I understand it to be, and his approach to be about ensuring that the rules that follow from the Supreme Court's determinations are ones that make sense and are workable.
He said recently, explaining his approach to interpreting a statute, you're not going to go outside the words, but it often doesn't give you the answer. And you look at the history, and you look at its purposes, and you'll look at the consequences too, and you'll try to evaluate them from that, the point of view of what a reasonable legislature writing this statute have thought that these words were there to achieve. Do you align yourself with that position?
In the broad sense that what it is that the court is tasked with when statutory interpretation is being undertaken is to achieve the purposes of the legislature. The text is the primary and in most cases sole indication of what the legislature intended, as opposed to the court saying, I see this statute, but I'm, uncomfortable with how it's going to turn out or what it's going to mean, and so I'm going to import my own policy perspective. Instead, the court is constrained to say, regardless of what I think the right policy objective should be in this, with respect to this law, my purpose, my requirement is to determine what Congress intended.
But with respect to legislative intent, when a Congress of 535 often distracted people, 100 in this body and 435 in the other, pass something, by a 2-to-1-ish vote, and it's a part of a large piece of legislation, how do you determine what the intent is when it's 535 people doing something that has many, many different purposes for why somebody might vote yes?
Well, you look at the text. I mean, the way in which statutes are interpreted is based on what the legislature says. There are times in which there are statutes in which Congress includes a purpose statement, for example, in the actual text of the statute. You look at the text of the provision. If that isn't clear, you look at the structure of the statute. There are canons of interpretation that courts use to evaluate and interpret statutes. Things like a word that appears in the section that you are interpreting should be defined the same way it is in another section. The same word being used, Congress probably intended for it to have the same meaning. So there are tools in the law that exist to help courts to interpret the text, but again, the goal is to interpret the text as a means of understanding and reflecting what Congress intended. And of course, in statutory interpretation, if Congress decides that the court has gotten it wrong, then, as has happened many times, Congress comes back and clarifies and tells the court, no, this is what the statute means.
I want to go back to an exchange you had with Senator Cornyn. Substantive due process is a doctrine that often allows courts to create new fundamental rights. What's the test for determining a new fundamental right?
The Supreme Court has said in the Glucksberg case that the fundamental rights that are recognized or that are included in substantive due process are those that are deeply rooted in the nation's history and tradition. In a case prior to that, the court had defined it as the rights that are implicit in the ordered concept of liberty or the concept of ordered liberty. So there are standards for the courts to use to identify these types of rights.
So did the Supreme Court use this test in Roe or Casey?
In Roe and Casey, I don't know that the court used that formulation. I know that after Casey, the court has determined not so much that the right to terminate a woman's pregnancy is fundamental. The right exists, and it's subject to the framework in Casey that allows for regulation so long as there's not an undue burden on the exercise of the right pre-viability.
I think some of what we're wrestling with here is the question of, and I think what Senator Cornyn was driving at, is how particular the concept of deeply rooted goes and how that really is a bound on what the judiciary can do. But I want to thank you. We're nearly at time. I want to thank you for engaging in the back and forth. I want to think more about what you've said and look forward to further discussion tomorrow. It still appears to me that there's a very basic difference between a judicial philosophy and a judicial methodology and how you go about applying that when you're interpreting a law and making a determination about constitutionality or non. And I know that you haven't claimed a judicial philosophy at all, but a judicial philosophy of originalism here. But I do think the fact that you've at least nodded to it in the committee hearing today is in and of itself a pretty great testimony to how much of Scalia and Bork's work has moved the legal field. So I'm grateful for the time you're taking with us. I'll look forward to listening tonight and talking with you again tomorrow.
Thank you.
Thank you, Senator Sass.